Marks a milestone in South Africa's democracy as the Constitutional Court marks 30 years of existence. Signed into law by the late President Nelson Mandela in 1996, it laid the foundation for a free and equal society rooted in human rights and justice. But some of the questions being asked are whether the Apex Court has done enough in holding government accountable and really achieving the objective of transformation in society. Let's talk about it with Professor Hugh from the Faculty of Public Law at the University of Cape Town and Dr. Tanveer, Jeewa, Constitutional Law Lecturer at Stellenbosch University. To the pair of you, good morning. And I want to say, for people who watch the Constitution and the law, congratulations to all of us, really, for watching the evolution of the Constitutional Court over these last 30 years. Dr. Jeewa, I'll kick off with you. In the first 15 years of the Constitutional Court, we did see some bold and principled rulings, the abolition of the death penalty to challenging even former President Nelson Mandela. What do you think were the key elements that allowed the court to establish such strong legitimacy during its foundational phase?
Thank you so much, Iman, for having me for such an important topic. I think there's a reason why they called that era the Golden Bench. Obviously, they were tasked with a very difficult task at this time. And like you've mentioned, the death penalty, even bringing President Mandela in front of the court. And I think one of the issues that we've talked about, even in Prof. Cordo's class at the time, is how the reaction of President Mandela, taking that judgment in his stride and, sending such a strong message about what exactly the Constitutional Court meant to this democracy, that he will respect the ruling, even though it goes against his decision, was extremely important in terms of what the Constitutional Court meant in terms of being an apex court. Obviously, that changed in terms of afterwards the jurisdiction of the court, which we'll obviously talk about later. But in terms of obviously setting the normative standard. So what do we mean by that? In terms of actually talking about what kind of society do we want in South Africa? And you've mentioned the death penalty. At the time, it was an incredibly hard decision to make. Even now, we all know that South Africa is not a society that actually does not want the death penalty. Oftentimes, you will talk to South Africans, they will probably want the death penalty back. Unfortunately, a lot of people think that violence is something that stops violence, but at the time, it was an incredibly important decision. We've seen a lot of judgments written even in that one judgment. A lot of people highlighting the importance of a value like Ubuntu, saying that you cannot take a life, to pardon what we actually saw. So the importance of the Constitutional Court at the time with such important decisions was incredibly saying that actually we need to stand up for what's important, for what society we want South Africa to be, not actually what we have right now, but for that bridge.
Well, let's draw an arc between then and now, because I think it's important in terms of presidential accountability. One of the first times that the Constitutional Court held a sitting president accountable, even someone as revered as Madiba. Prof. Corda, you noted a significant turning point around 2009, marked by weaker judicial appointments and growing external pressures. To what extent do you think, as you reflect, has the Judicial Service Commission contributed to what's described as the erosion of the court's authority and credibility? And what reforms do you believe are urgently needed?
Thank you for that. Could I just make two remarks in relation to the answer to the question that Dr. Jeewa has just given? One is, we obviously in 1994 faced a massive democratic deficit in this country. And we were in the interim constitution, and we are blessed with an extraordinarily progressive constitution, which the judiciary has taken enormously seriously. And with the use of language and the judicial interpretive function, judges were able to push the boundaries, but let me be very clear, never overreach their authority. There is something in our law called the separation of powers doctrine. It's not in the Constitution in those words, but the ConCourt decided early on that it was implicit in the Constitution. So the judiciary has stayed within the bounds of its authority. And the second major point about those first 15 years or so is that if you look at the judges who were on the bench then, all of them, almost all of them, had a considerable record in political struggle. They knew the leading figures in the executive. They knew how far they could push, and they were by the same token respected by President Mandela, President Mbeki, and others. Then we had the watershed of just after President Motlante's presidency. We had the Zuma years. And President Zuma's style of government and his value system is alien to our constitutional value system. And the JSC is one of the ways in which the executive branch of government can try to counteract judicial authority by seeking to appoint people who I won't say are manipulable, but people who may be less strong on the constitutional values. I don't think the JSC succeeded at the Constitutional Court level in doing so. But I certainly think there were some bleak years in the history of the Constitution, of the JSC, in its broad mandate to appoint judges. And I can say a lot more about that if you want me to, either now or later.
Well, let's see how we do for time, but I want to circle back to just teasing out the concept of when you referenced Jacob Zuma talking about his value system being alien to the value system, I think you said, of the court itself. Just explain exactly what you mean by that.
Okay, so the critical section in our Constitution is Section 1. It's the most equal of all the sections of the Constitution, if I can put it that way, because to amend Section 1 of the Constitution requires a 75% majority in the National Assembly and the agreement of 6 of the 9 provincial parliaments, not the 2/3 majority which applies in respect of every single other section of the Constitution. And what does Section 1 contain? Why is it so important? It contains the value system on which our constitutional democracy is based. It talks about human dignity, the promotion of equality and freedoms. It talks about non-racialism, non-sexism, supremacy of the Constitution and the rule of law, and regular elections in order to ensure a multi-party democracy which promotes accountability, responsiveness, and openness. Now, that's a magnificent package, aspirational package of values, which the ConCourt can rely on to guide itself in its judgments. And I'm afraid I think there's broad agreement that President Zuma and those whom he appointed to high office did not share that set of values. Indeed, if one looks at the party which now is headed in our parliament by Mr. Zuma, they want a return to parliamentary sovereignty. Now that means, we have this horrific history in this country of parliamentary sovereignty, that 50% of the electorate plus one represented in parliament can do away with any rights, as they did under apartheid. And that's what Mr. Zuma's party wants if it comes to power. And that presumably must express what his value system is.
And I think what you've highlighted there is perhaps this ongoing tension between majority rule and constitutional supremacy. And the Nkandla judgment, though, does stand out as one of those rare moments of judicial consensus and public impact in recent years. Let's go on then, Dr. Jeewa, to another aspect, because we could spend, and I'm sure you've lectured extensively on this, Prof. Korda. There's so many areas we can go to, but I want to go to the argument, Dr. Jeewa, that critics are making, that the Constitution is an elite, Eurocentric document that has failed to deliver meaningful transformation in South Africa. How would you approach those claims? Do they hold water?
I think it's a very complicated conversation to obviously have in such a small amount of time, but I will attempt to do my best to do it justice right now. So obviously this argument has 2 prongs, right? Meaningful engagement and also transformation in terms of what's actually happening on the ground, right? So I think anyone who is in love with the Constitution or even fetishizes the Constitution will tell you that, yes, there isn't actually on the ground meaningful socioeconomic transformation in the way that even people who've drafted the constitution wanted it to happen, right? Unfortunately, that hasn't happened. Not as many Black lives have been impacted by the constitution as meaningfully as people wanted to, even people who've drafted the constitution, right? I'm sure everyone will agree to that. Unfortunately, way too many people are still in poverty in South Africa. No one can lie about that. I mean, you will drive from the airport through Khayelitsha to Camps Bay and you will see the poverty, and you cannot lie about something like that. So unfortunately, we have to agree to that. Now, the next question becomes, was the constitution the means through which all of this should have been achieved in 30 years immediately? Then that's a different question entirely, right? And the next question becomes, is the constitution the reason why this hasn't been achieved? Is also a different question. Whether there has been corruption and whether that has been a lot of the reason why this meaningful transformation hasn't been achieved is also another thing that we need to talk about. So a lot of the times, the question that I then ask is, if a lot of the transformation that has been envisaged by the constitution had actually taken place the way it had been envisaged when the constitution had been drafted, would we still have been in the same place that we are now? I am highly doubtful, right? I will be honest and admit that even I am skeptical about the constitution sometimes. And I will say that because I'm a property scholar, I deal with Section 25, I deal with land reform. I think it's impossible to deal with land reform and not to be skeptical about Section 25. But even then, I have to ask myself, if the land reform programs that have been put into place and housing in 1994 had been achieved the way it was meant to, without corruption and with all of the budget going where it was supposed to, I highly doubt we would be dealing with the housing crisis we're dealing with now. There's a bigger housing crisis now than there was in 1994. Is that even possible to contend with after apartheid ended? That is shocking to me. So I think it is a little bit of a cowardly cop-out to put it all on the constitution being a Western construct. And I think we do need to stop and ask ourselves, where else in the world, maybe only one or two countries, and not in the Western world, have we actually meaningfully engaged with the population at the level that South Africa has when the constitution was being drafted? And that is not a Western construct. It might not be an African construct the way people deal with indigenous law is, but it is not a Western construct. And I do think it's a cop-out to then say that the reason that South Africa is quote unquote failing the way people are saying is because the constitution is a Western construct. I think that is stopping at a little bit too much on a superficial level as a debate. And unfortunately, as I said, I don't think we can do it justice in a 2-minute answer, but I do hope that that kind of at least addresses it as superficially as the debate puts it.
Yeah, I think that's, as you say, and rightfully so, it is, it's a multi-headed animal, and it would be hard to kind of answer it all in a very short interview. I'd love your thoughts on that, Prof. Corder, and one of the themes that Dr. Jeewa evoked there was this meant to be the panacea, and I mean, I'm sorry to use a cliche, a panacea for all South Africa's ills as a corrective measure, the Constitutional Court as the embodiment of South Africa's constitution?
So, thank you for that, and thank you for the answer, Tanveer. There's no doubt about it. We live in a more socioeconomically unequal society, massively so, than existed in 1994. Everybody acknowledges that. But is it the fault of this little document, the Constitution of the Republic of South Africa? Now, first of all, for me, it's a social democratic, not a liberal democratic document, or envisages a social democratic society rather than a liberal democratic society. It expressed at the time of its drafting in 93, 94 to 96, it expressed the best of constitutional scholarship and experience in the world that was liberating itself from the Soviet Empire from the late 1980s onwards. And we took our lessons also from the failings of American jurisprudence, European jurisprudence, and so on and so on. So, but these are just words on a page, okay? They need us, human beings, to express them and to give real meaning to them. Secondly, No court has the right to create an opportunity to pronounce a judgment. The court has to wait for parties to come to it, to bring a dispute to them, to bring an allegation that the government, the parliament and the executive, the other two branches of government, have failed in their duties which are laid upon them by the Constitution. And the judgments of the court are replete with those kind of examples, including the Nkandla case, including the Treatment Action campaign case from 2002, and so on and so on. I lay the blame or the responsibility or the accountability squarely at the doors of the executive. Parliament has enacted some excellent laws over the past 30 years or so, and we have a gross failure by the executive authority to implement those laws and to be proactive in terms of those laws. So, and I think we have the judiciary to thank for where we are now. I think we would have been deeper in trouble had the ConCourt not played the role that it has.
I want to stay with you, Prof. Korda, just for a second around accountability, especially when it comes to the executive. The ConCourt has historically delivered rulings that have upheld socio-economic rights. And the question is, can it still be seen as effectively holding government to account today? And again, it's about that expectation that we have from the court and the limitations provided by the framework of the Constitution. But when we think about matters involving accountability in the executive, like Phala Phala or the Section 89 panel report, how well has it done?
Yeah, I think that it's done pretty well, and I will use two examples perhaps. One is the Constitutional Court judgments. You will know that, seen different figures, but at least 17 million South Africans depend for their survival from month to month on social grants. In 2015, 2016, the then Minister of Social Development, Patabile Dlamini, through SASSA, decided that they would put out to tender to ask a commercial enterprise to administer and to pay out the social grants. They awarded the tender in a corrupt manner to Cash Paymaster Services, and one of the disappointed tenderers, AllPay, challenged that in the court. The court was magnificent in its judgments. It held the minister even accountable for costs in that case. They cancelled the tender, the award of the contract, and they have moved us back to a situation where SASSA continues to pay out the grants in some way or another. But that is still live because we're still waiting for Cash Paymaster Services to pay back some of the profits that they made in those years. So that's a live issue. The second one happened earlier this year. Late last year, you will recall that the MK party decided that Dr. John Hlophe should be its representative on the JSC. That was taken to court by a bunch of litigants, and the court first of all declared that he could not take his seat up in the JSC, and then just 2-3 weeks ago, a full bench judgment held that Parliament had acted irrationally in doing so. Now there are some who argue that the judges went a little bit too far on the doctrine of the separation of powers in telling Parliament what it could and couldn't do. And one has to watch the judiciary, because the judiciary, as an exerciser of public power, is also to be held accountable. And that's what some of what academics do, and other commentators, they criticize the courts, but in order, I hope, mostly to hold them accountable to the value system of the Constitution. So I think the courts have done overwhelmingly well, and I think that the ConCourt has led brilliantly, and I think that the Constitutional Court has not exceeded its constitutional authority. It has not overreached, which is the word which is often used. Yeah. I hope I've answered your question a little bit.
You have. And I want to go back, though, in concluding our discussion, Dr. Jeewa, to that accessibility in the same way that I think, and Prof. Korda, you've written about this as well, that it really is civil society's responsibility to kind of join hands and hold the Constitutional Court accountable, or to be connected to the work that it does. I want to end on the theme of this design of the Constitutional Court. If you've ever sat in there, you know that you can see, people walking past the building itself. In its design, it's meant to promote transparency. It's meant to be inclusive. People can walk in through those gates and observe matters being adjudicated by the bench. How much more outreach do you think it should be doing, Dr. Jeewa, in maintaining that connection with society and continuing to let people know that this is a court for the people and about the people?
I will tell you something, that at the court, while I clerked there, one of the things that I found was that there were a lot of committees at the court, right? And part of the things that we used to do is also be in charge of doing tours at the court, and that included art tours, but that also included hosting sometimes other people from abroad, but that also included sometimes art tours for other people who were visiting. And when you would do that, you would find a lot of people actually visiting the hospice of the court itself and coming inside, and people from all different nations, but including South Africans who had never been in the court before. And sometimes when I would go to the court myself to work, and on the way there, this is kind of a story now, I would speak to an Uber driver and they would tell me, oh, they wanted to do law, but they'd never been inside of the court. And I would tell them, well, actually, it's free. You can go inside and visit. And they would come and visit. And that kind of accessibility is something that you don't see in other countries when you go to other courts. And other courts feel so almost formal and out of reach, and you don't feel that way when you go to the Constitutional Court. And I know Prof. Korda would agree with me. There is something very warm about the Constitutional Court when you go inside, when you see the art, when you touch the copper doors, even the sign language and the braille that is depicted outside. There is something very warm and welcoming about the Constitutional Court, something that sets it aside. Even when you look at different courts in South Africa, actually, even the SCA and the High Courts, there's something about the Constitutional Court that sets it aside from other courts. And it's something that I hope that we keep on, not only with the tools, but also in the work that it does, even in the media summary, something that seems almost so silly and minute, but is so important because people who are not lawyers are able to actually access judgments. Not everyone has the time to read through 124 pages, let alone of legalese, right? So having 2 pages of the judgment summarized means so much to even people who aren't lawyers. So I think accessibility should mean so much more than just having access to the physical building. It also means having access to the work of the court. And I really hope that they actually keep up with broadcasting the hearings, even online, through that YouTube channel that they had. I know a lot of us had a lot of fun watching the YouTube hearings, and it means a lot for people to see what justice being actually played out looks like, because it makes you feel much more in touch with what the Constitution says and what it actually looks like to see judges on the bench and actually giving out that justice. So yeah, accessibility in all forms. I hope they keep it up.
And I love one of the first things you see before you even access the gates, Tanveer, is the flame of democracy. I've shared a tear or two there, taking some people there, especially when you consider the historical import of the site itself, which is, built on the site of the former prison. This is the old Fort Number 4 prison built on those grounds. I really do want to appreciate the both of you. I'm really getting some messages from people saying, wow, this is so informative and just sheds and creates a different dimension of understanding when it comes to the country's ConCourt. Professor Hugh Korda, huge thanks to you. Dr. Tanveer Jeewa, thank you as well. And I'll allow you to continue watching these proceedings live on Channel 405. We're broadcasting picture now from the ConCourt, and you see a number of luminaries, judicial luminaries,